You've sued your doctor for medical malpractice. You suffered horrendous injuries as a result of his carelessness. And now you believe not only do you have a solid basis for a case, but you also believe that your case is worth $5 million. What happens if the defense doesn't see the value of your case the way you see it? What are your options? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. So now, when the defense doesn't see you eye to eye in terms of the value of your particular injuries, now you have only two options. You go through the course of the litigation process with an end view of going all the way to trial, with the ultimate outcome being that a jury will make that decision about how much your case is truly worth. That's one option. Another option is to seek mediation. Now, that's an opportunity to have a private conversation with an impartial judge where each side gets an opportunity to explain their position. Each side has an opportunity to negotiate, and now you have this impartial judge who now puts pressure on both sides and gets each side to realize that there are holes in the case, bringing the case, and there are holes defending the case. Getting them to realize and recognize that there are risks to going forward, there are risks to defending the case. And now the mediator, this impartial judge, his goal is to try and get the parties to come together to reach a compromise so that maybe the case is not really worth $5 million. And now the defense looks at it and says, you know what, we think it might be worth maybe $2 million. Well, now you have to decide whether or not you might be able to live with that amount of money. And now the defense has to recognize that, hey, if they go to trial, there's a significant risk that a jury could give you significantly more than what you're asking for in this particular case. So to go back to the original question, what are your options if the defense does not see eye to eye and does not value your case the way you value it? Well, your only options are really two of them. Either go all the way to trial, take a jury verdict, and then have to deal with post-trial motions to try and reduce your verdict or get the verdict thrown out. Then deal with appeals, and you always have the uncertainty of what's going to happen on an appeal. Or you try and deal through mediation. And now, just because you go to mediation or try it doesn't mean you're going to be successful in resolving your case. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what happens in these medical malpractice cases here in New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.